Greetings, welcome. My name is Stephen Elliott. I'm a member of the faculty at NUS Law. I teach trusts, and I see a number of my colleagues as well who are also in our trusts effort. Today, I'm going to introduce you to Professor Charles Mitchell. He is a professor at the University College of London. He's one of the common law world's leading trust scholars, without a question. His works have been cited and relied on by the United Kingdom Supreme Court many times, and also, of course, by courts elsewhere in the common law world. He is an author of Goff and Jones on the law of unjust enrichment. He's also one of the authors, perhaps more relevantly for tonight, of Underhill and Hayton on trusts. In addition to that, in addition to his work on textbooks, he is the author of many, many articles exploring new and, in many cases, very exciting directions in private law scholarship. We are fortunate to have him in Singapore today. Charles Mitchell, will present to us new ideas he's been developing with Jessica Hudson, who is a scholar and barrister who lives and works in Sydney, Australia. These ideas concern standing in the law of trusts. Standing in private law more generally is a topic that was pioneered by NUS's own son, Timothy Liau, who now teaches at the London School of Economics. Charles Mitchell and Jessica Hudson have turned the focus on trust law, which seems especially promising. We have a basic model in our heads of a private law claim which is simple and bilateral. A right holder sues someone who has violated those rights, usually someone who owed them a duty. Think of claims for damages, for breach of contract, or for tort. A simple bilateral claim. And the standing belongs to the right holder. At one level, Professor Mitchell's presentation will remind us that trust litigation is much more multifaceted than this. There are simple bilateral claims by beneficiaries against trustees. But there are also many other possibilities Professor Mitchell will outline. He may even persuade you that the simple bilateral claim in the context of trusts is the exception, not the rule. And if that was all there was to the lecture tonight, our time would be well spent. But there is more. The lecture also takes us to a more fundamental level. Charles develops his points about standing into a radical critique of the beneficiary principle. This is a principle right at the center of the way we think about trust law. Principle we all learned about in law school. It says that every trust must have a human beneficiary who can enforce the trustee's duties. Charles may persuade you that this principle is subject to so many caveats and exceptions that it would be better to start again from a new place. You can therefore look forward to the best kind of public lecture, one that invites you to reconsider your basic assumptions about a subject from a new perspective. I won't say anything more other than to invite you in joining me in welcoming Professor Mitchell.
Good evening. I thank the Centre and the Faculty of Law for inviting me to give this lecture this evening. Which, as Stephen has said already, on standing in trust law, the beneficiary principle and trustee duties. As Stephen's also mentioned, but as I'd like to say, the work I'm going to present to you this evening is work which I've done in collaboration with my friend and colleague, Dr. Jessica Hudson, who was formerly a full-time member of the faculty at University of New South Wales, but has now gone to the bar in Sydney. And as often seems to happen when I do work with Jessica, we start off with an idea and we think, you know, we could probably write about half an article on it, and then we talk about it for about a year, and by then it's turned into 2 articles or maybe 3 articles, and so we then have to try and put it into some shape and cut it down. But we've wound up with 2. What I'm going to cover today is points which we make in the first one, which is it's about to be published in the Law Quarterly Review. So, standing rules in private law. What are they? What is standing? The word standing will be familiar to everybody here who's a practicing lawyer, but probably not thinking about it all that much, and certainly not thinking about it in a particularly theorized way. But I mean, I guess when as practicing lawyers we do think about it, we tend to just think, well, it just means standing to initiate legal proceedings, and that's sort of pretty much it. And Jessica and I think that that's an inadequate kind of summary of what standing actually is, for 2 reasons. One is that standing it's a set of powers to enforce legal rules in court proceedings, and they subdivide into powers to become a party to proceedings, and then powers as a party to make choices about how the proceedings are going to be run. Now, the first point there, standing, the power to become a party to proceedings, not just as a claimant, but as a defendant as well. And people often overlook that because they think, you know, perfectly reasonably, that if you're a defendant to proceedings, that's just something that's happened to you because somebody who you probably don't like very much right now has just issued proceedings against you, and they're asking the court for a remedy, and so there you are, you're a party, you didn't choose that, but there you are. I think it's a bit misleading to assume that people only become defendants to proceedings because somebody else has chosen to sue them. In some circumstances, people can join to proceedings as defendants of their own volition. So there is, in some circumstances, an exercise of choice by a party to become a defendant with the court's permission. But secondly, and maybe in some ways more importantly, standing isn't just about becoming a party. It's also about the power you get as a party to make choices about how the proceedings are going to go, what claims you're going to make if you're the claimant, what defenses you're going to raise if you're the defendant, what legal arguments you're going to run, what evidence you're going to lead, whether to settle or discontinue, whether to appeal adverse findings, and so on. And everyone here who's in practice and familiar with litigation will know that there are a lot of choices to be made. But after you've made them, the operation of procedural and evidential rules is going to make those choices legally binding on the parties and you know, potentially on other parties too, by operation of judgment estoppels and so on. So standing matters because people who have standing they're playing a very important function inside our legal system because they're making choices about about the legal arguments which will be presented to a court and supported by things which the counsel say, and the choices which the court then makes about how they're going to decide the case and what make our law. Now, for a long time, people thought there weren't any standing rules in private law. That was a sort of public law thing, right? So public lawyers write articles about standing in public law to bring judicial review proceedings or other kinds of proceedings challenging administrative action. And there are rules which are designed to keep some people out of doing that. So the standing rules in public law, their point is to say, is really to identify people who the court thinks has a sufficient interest in the litigation to be allowed to bring it, and discriminate between those people and the ones who they're going to exclude. Because on the public law side, the courts have said quite a lot about that and what counts as a sufficient interest. That in turn has generated quite a lot of academic commentary. But over on the private law side, it's like a desert. Yeah? And Peter Kane in 2011 sort of expressed this view, which was very commonly held, that standing is just not normally a requirement for bringing a private law claim. There aren't any special standing rules. The problem with that, though, is that going back for many, many years, there have been many cases in which the courts have considered and decided whether or not they're going to let people bring particular kinds of civil proceeding. So that it just doesn't add up, this idea that there aren't any standing rules. If that's so, then why are the courts kind of making decisions about whether people can or can't bring particular claims? I think it may be that some of the time they were effectively applying a standing rule but didn't recognize it as such because it was sort of rolled into their analysis of whether or not a claim would be viable on a particular set of facts, and if it wasn't, then they'd say you don't have standing to bring it. But that's a confusion of ideas, right? Whether or not the law discloses a cause of action in a particular situation is not the same idea as who is it who's entitled to rely on that cause of action in court proceedings. Now, as Stephen has said, a graduate of the National University of Singapore, Timothy Liau, recently wrote a very good thesis, which he turned into a book called Standing in Private Law. And I enjoyed reading it very much, and I recommend it to you. But the big point he's making is that there are, in fact, various standing rules which empower some people and forbid others to enforce claim rights in court. And having made that point, Tim then elaborates on what he thinks those standing rules are. Still more recently, although he's been working on his project for a long time, an Australian academic named Kit Barker, who's based in Brisbane at the University of Queensland, makes a similar point in a book which has not quite yet appeared, although I've had the pleasure of reading it in proof. It will be published by OUP this year. And Kit says there are various rules which allocate what he calls rights of action to some people and not others. I think his terminology is a little misleading, because when he says rights of action, it sort of looks like he might mean claim rights, but he doesn't mean that. What he means is powers to initiate proceedings in public law and private law, and liberties not to refrain from doing that. So Kit's book covers a wider field than Tim's, because he's interested in public law as well as private law. But they both have the same basic point, which is having a claim right, a right which you can enforce which you can rely on to get a remedy from the court, isn't the same thing as being a person who's entitled to to invoke that right in order to get a remedy. They're different, and once you've recognized that they're different, then there are important questions which arise about what the standing rules are. One point I should make about both Tim and Kit's scholarship is that they're focused on standing to enforce rules in court to support a claim, and neither of them really say very much about standing to defend. But for the reasons I've already given, Jessica Hudson and I think that standing to defend is also important because defendants, as well as claimants, are people whose choices affect the conduct of proceedings and the outcome of litigation. So, I want to introduce you to this idea of directed duties. So, many private law theorists would say that private law relationships are exemplified by those between contracting parties and tortfeasors and tort victims. And what they have is a sort of bilateral correlativity, meaning that one of these parties has a claim right against the other, and the other has a duty which correlates with the right. So they're sort of locked together in this bilateral correlative relationship, right and duty. And duties of that kind, you know, the legal theory guys would call those directed duties. And they're different from undirected duties, as you might have guessed from the language, where it's a duty, but it's not owed to anyone with a correlative claim right. Although you can allocate powers to enforce the duties to individuals. And I would say, Kit disagrees with me about this for reasons which I don't need to talk about today, but they're exemplified by the duties of public officials exercising administrative powers. So if you're a public official and you have a duty, I don't know, to make some planning decision, a power to make a planning decision, and you make it, you're governed by rules which require you to make it in a particular way. They're sort of mostly process rules. You have to take relevant considerations into account and exclude irrelevant ones. You have to make your decisions in a rational way and so on. And you know, I'm sure that those of you who remember your public law before going into trust practice may dimly remember there are these rules of public law about how decisions have to be made. Those are duties, but they don't correlate to claim rights, right? Because public officials, when exercising powers, are doing that in a way which affects everybody in society, but it doesn't mean that everybody in society has a right against them which corresponds to their duty. These duties are at large, they're undirected. So you ask, well, how does they ever get into court then? The answer is because there are rules which allocate standing to enforce them to people, but those aren't people who have rights. Now, assuming that contract and tort duties are directed in the way that I've described, scholars have argued that there, as a general rule, the standing rule for contract and for tort is a very simple one. Standing's allocated to the right holder. And the idea of that is that it's a way of vindicating your rights. That if somebody owes you a duty and you have a corresponding right, then you're the person who gets to enforce it in court because you know that's why having the right is worth something to you. And a kind of one theory writer, American, called Benjamin Zaborski has made that argument in the piece which I've written there, and that's also the argument which you'll find in Tim Liau's book. It's a very simple rule. Standing is allocated to right holders. Standing to enforce directed duties is allocated to right holders. Although exceptionally, you might give it to people who aren't right holders, but acting on behalf of people who are. So a right holder might consent to somebody else acting on her behalf, or they might be incompetent to act on their behalf, in which case someone else will have to do it for them, but it's still their right and their standing on Tim's view of the world. So that's contract and tort. So I was in Australia. I was reading Tim's book. I was thinking about this. I was working with Jessica on a different project in Sydney. And I was saying to her, well, you know, I've been reading this book about standing, which Tim Liau's just written. And, you know, my intuition is telling me that trust law doesn't work like this. I don't think that this is the right model for trust law. And so Jessica and I then spent a lot of time sort of batting that backwards and forwards and why that might be. And in the course of doing that, we read some parts of Lionel Smith's book called The Law of Loyalty, which is a very broad book which covers a lot of ground, but which is primarily about fiduciary duties, but he also says something about the topic which I'm talking about this evening. And the moves he makes in his book on that topic I've set out for you there on the slide. He first of all says, well, you've got to distinguish beneficiary trusts and purpose trusts. And if you have a beneficiary trust, the trustee's duties are directed towards the beneficiaries who have corresponding rights, and you have a right holder enforcement standing rule. They get to enforce the duties because they're the right holders. You might sometimes have trustees suing other trustees, but when they do that, they're doing it on behalf of the beneficiaries. It's not because they have their own rights or standing. Exceptionally, though, Lionel says, purpose trusts are different. There aren't any beneficiaries. They owe undirected duties. You therefore must have a different rule to say who's got standing to enforce them, because there isn't a right holder who's there in the picture. That's how Lionel sees the world. And he's got some support for that in the cases. Lord Briggs in Halabi, or is it, maybe it's Lord Hodge actually. Anyway, it doesn't matter. A trust is essentially the obligations enforceable in equity against the trustee. Put purpose trust to one side. Equity enforces those obligations on the application of the persons to whom the obligations are owed. Generally the beneficiaries. I'm not sure who else it might be if it's not the beneficiaries, but that's a sort of classic, that's essentially Lionel Smith's view of how it works. And one of the reasons why I'm not happy with that view is I don't think it's true that that's what a trust essentially is. I think there's a lot more to trust than just trustee-beneficiary relationships. There's a lot more to it. For reasons I'll explain in a moment. In Brake, in the Supreme Court, the court sort of makes a similar point. Fiduciary duties are owed to the beneficiaries of the trust. So the beneficiaries are the people who get to enforce them, not anybody else. Now, in Lionel's mind, this is linked up with the beneficiary principle. And you can see that in a well-known article that he wrote about massively discretionary trusts, where he objects to this way of trust drafting, which the kind of trust structure he has in mind is where a settlor creates a trust, the benefit of a class of beneficiaries, which at the time of the drafting is a named charity like the Red Cross, and anybody else who's appointed into the class by the exercise of a power to appoint people as beneficiaries out of another group of people, which is including everybody in the world apart from the settlor and the settlor's spouse. And Lionel doesn't like trusts like that because he says the Red Cross has no interest in enforcing these trusts because it knows that they're not for them. And he says nobody else can enforce them because there aren't any other beneficiaries until the power to appoint new beneficiaries into the beneficiary class has been exercised. And it's important for Lionel's analysis that he would say the fact that they're the object of a power of appointment into the beneficiary class doesn't give them standing to enforce the trustee's duties. And he says, the letter mirror object do that is straightforwardly inconsistent with the beneficiary principle. So what does he mean by that? What is the beneficiary principle? Well, we need to unpack it a bit, because the way, as Stephen has said already, the way in which you get it when you're a student is it's presented to you as a rule about purpose trusts. And the idea is that they're just void unless they're charitable. And there are a number of well-known authorities which establish that. Bowman and Secular Society, House of Lords, Leahy, Privy Council from Australia. There are these judicial statements. No beneficiary, therefore void. But we need to dig into the rationale for that rule, and I think there are two different ones. So one of them is, unless trustees owe duties of due administration, by which I mean duties to comply with the terms of the trust when they deal with the property, and someone has standing to enforce those duties, there can't be a trust, because effectively you've given the property to the trustees, you've told them, oh, you've got to do this or that with the property. But if there's nobody who enforces their obligation to do that, they won't do it. They'll just keep the money for themselves. And so there's not a trust there. You've just made a gift of the property to them. That's the sort of idea. But you need to notice that it's also a second feature of the beneficiary principle, that the enforcer has to be a beneficiary. It can't be anyone else. It has to be a beneficiary, and wrapped into that seems to be this idea, which Lionel Smith certainly believes in, and the courts in the cases I've cited to you seem to believe in, that trustee duties are directed to beneficiaries who have correlative claim rights, and so they're the ones who has standing to enforce the duties, because there's a right holder enforcement standing rule. And that seems to be what Lord Justice Millett is saying in Armitage and Nurse when he says if beneficiaries have no rights enforceable against the trustees, there are no trusts. That's quite a succinct statement, but I've tried to unpack it for you in the middle paragraph there. So, for me, I should start off by saying it's not my position that the cases in which the beneficiary principle has been articulated, don't exist, because obviously they do exist. It's not my position they don't form part of English law, because they do form part of English law. The problem, though, is that they're inconsistent with lots of other bits of trust law, which also form part of English law. So if you view all of trust law's rules as a whole, as a system, there's an inconsistency inside it. And so question for us all who are interested in trust law, not just from an abstract theoretical sort of way, but in a very practical way, is how much does that inconsistency matter? And if you're involved in trust litigation, as your practice area, it comes to you as there's a set of problems. There's a rule which is the one that you would like you think is in play, and essentially then your focus is on, is this rule going to apply or not? And what you're not thinking about is all these other bits of the law around here which have got nothing to do with your problem, but which seem to be founded on premises which are completely different from the one which matters to you in the litigation. So what have I got in mind here? Well, there are four things which I will take you through. One of them is there are lots of bits of legislation and cases which you look at them and they're just clearly allowing people who are not beneficiaries to enforce trustee duties. And Lionel would want to say, well, some of them are exceptions because it's a charitable trust and that belongs to a sort of special group. And then the rest of them, they are really the beneficiaries' kind of standing powers, but somebody else is using them as their beneficiaries' representatives. The thing is, there's no sign of that analysis in the case law. Secondly, looking more broadly at the beneficiary principle, it's part of the history of trust law. In the past and right now, it's been permissible for trusts to have no beneficiaries, either at all or for periods of the trust's existence. Now, that's just not consistent with the beneficiary principle, which says there must always be a beneficiary. Thirdly, when you look at the remedies which are awarded for breach of trustee duties, they're not personalized to beneficiaries. And fourthly, I want to say something about trust litigation, engaging the court supervisory jurisdiction, and the argument I will make there is that this sort of adversarial beneficiary trustee litigation is not actually very representative of most trust proceedings, which are much more commonly about other things. So, starting with the first one, you look at the cases in the legislation. Who actually has standing to enforce trustee duties? Well, we start with the one which is sort of uncontroversial, the beneficiaries of fixed trusts. And that's consistent with the line that it's all about directed duties between beneficiaries and trustees. And I'm just putting them up there for completeness. It's just obviously true that beneficiaries of fixed trusts can bring proceedings against both trustees and third parties following a breach of duty. Then we move into slightly trickier territory because we're moving into beneficiaries of discretionary trusts and objects of mere powers. Now, as was observed by Lord Walker in a well-known Privy Council case called Schmidt and Rosewood, which was about disclosure of trust information, neither a discretionary trust beneficiary or an object of mere power has an entitlement to a fixed and transmissible beneficial interest in the trust fund in the way that the beneficiary of a fixed trust does, and yet they have standing to get an order from the court that the trustees disclose trust information to them. So if you just think about it for a moment, you're the beneficiary of a discretionary trust, or you're the object of a mere power. You're sort of hoping that the power holder is going to exercise it in your favor, and you're then going to become entitled to something out of the trust fund. But that hasn't happened yet. Nevertheless, you are considered to have a sufficient interest in the way that the trust is being run to make you a person who the court will recognize as being entitled to look at the trust information, the trust deed and the trust accounts and so on. And it seems to me, although Lord Walker doesn't quite come out and say it in Schmidt, but it must be what he has in mind, that he's also thinks that these people have standing to bring proceedings against the trustees if, when they look at the trust accounts, they find that half the trust fund's gone missing. What's the point of giving them that information unless you think they're going to do something with it afterwards by bringing proceedings? The cases underneath that are mostly Australian, apart from Whaley. They established the same principle that objects of mere powers, the Australian courts have said over and over again, they've got standing to sue trustees for breach of duty. Lionel Smith in his massively discretionary trust article denies that, but the Australian authorities are against him there. Trustees. People often overlook this, but very often proceedings against breaching trustees are brought by other trustees. Maybe that some kind of problem comes to light, either a fraud or just sort of incompetence. Some of the trust funds gone missing. In that kind of case, what's likely to happen is that the trustee is going to be sacked and replaced by somebody else. But the first move that the new trustee is going to make is going to be to sue the former trustee to reconstitute the fund and put back the missing money. And there's authority which says you can do that. Trustees can also bring proceedings in equity against third parties to whom property has been misdirected, either a proprietary claim or a claim in knowing receipt. when we teach knowing your seat to our trust students, it's always set up as though it's always going to be the beneficiaries who are bringing it, but actually there's plenty of authority which says that the trustees can bring it. So that sort of is looking like really the trustees have got their own standing. They're not, it's not like they're relying on the fact that the beneficiaries could be bringing a claim if they wanted to. The trustees just can do it off their own bat, and they frequently do. Donays of powers. So if you're in the British Virgin Islands or the Cayman Islands, it's permissible under their legislation to create trusts for private purposes and or beneficiaries. If you'd set up a Cayman Star Trust, it could be a beneficiary trust. But inside your structure to allocate standing to enforce the trustee duties, not to the beneficiaries, but to somebody else who's got a power to do that. So as far as those jurisdictions are concerned, it's not a kind of beneficiary-only standing rule. Something which many English trust lawyers are unaware of because they stay a long way away from pensions law because there's way too much regulation there to worry about. So they think, oh, I don't want to do any pension trust because then I'll have all this horrible statute to worry about. But so they don't notice that there's a lot of stuff going on inside pensions law, which is about trust law generally. It's not about statutory regulation. It's about core principles of trust law. And one of the things which it's quite clear from the pensions cases is that a pension scheme is set up by an employer who typically gives themselves powers to tell the trustees what to do, to veto trustee decisions, to vary the terms. There's all sorts of powers which employers give themselves inside pension trust structures. And those employers have got standing to bring proceedings against the trustees if they think the trustees have done something which they don't like. Okay, those employers, they're not beneficiaries. They're not, the beneficiaries are the members. So I think that's, those cases they're not just sort of weird little pension trust cases we don't need to worry about, right? These are central, these are real trusts. Pension trusts are real trusts, and apart from financial and investment trusts, pension trusts are where most of the trust money in the UK is held right now. So trying to form a view of how trust law works, which marginalizes pensions trust, is leaving out one of the major players. So it's a weird thing to do. And, trust law scholars need to wake up and pay more attention to pensions. Charitable trusts, Attorney General, regulators, people who are interested, all these people under statute have got standing to bring proceedings against trustees. And, nobody really disputes that, and nobody disputes that they don't have rights against the trustees corresponding to the trustees' duties, but the people who sort of favor that view of the trust law world, their way of explaining these rules is that charity trusts are exceptional. I sort of feel like charity trusts in the same way as I do about pension trusts. I want to have an explanation of how trust law works, which works for all trusts, not say, oh, well, that large collection of trusts over there doesn't fit with my theory, so I'm going to sort of put it over there somewhere and forget about it. You have to come up with an explanation of everything. And, there are other regulators, pensions regulators, investment, financial regulators. Australian and UK legislation gives them standing to bring proceedings against trustees as well. So all these cases, the way I see it, are not consistent with the premise of the beneficiary principle that you have to have a beneficiary and a trust in order for the trustee duties to be meaningful, because there are all these other people who are not beneficiaries who have standing to enforce the duties. So there it is, trust law standing rules. It doesn't have a general right holder enforcement rule. There are two principles. One is public officials are given standing to carry out regulatory functions. Private individuals get it when they have an interest in performance of the trust, which is generated by their status inside the trust as one trust party or another. And you can tell who they are by reading the trust terms. But a sort of interesting point there is that effectively trust law is letting settlors choose who they want to allocate standing to enforce trustee duties, and they can choose parties of, who they want. So that's my first point. My second point, I'll remind you, because I said it a while ago, the point of this section of the lecture is to make the argument that the beneficiary principle is inconsistent with chunks of trust law where trusts have been upheld as being valid, although they don't have any beneficiaries either ever or for periods of the trust's lifetime. So the obvious example is a charitable trust. But apart from those, there are other purpose trusts in history and now which are understood to be valid, although they are not charitable purpose trusts. So one example is what would now be thought of as a kind of quis-close trust. In the 19th century, if you lent money to somebody for a particular purpose, the way that the courts would analyze that would be to say, well, there's a trust for the purpose. Now, since twin sectura, trusts of that kind are analysed in a different way now. But in twin sectura, Lord Millett looks back at a case called Gibbet and Gonard, and he says, the way that this was analysed was that money is being held by the borrower on trust for application to the purpose. And the purpose isn't a charitable purpose, but the courts have no problem with setting up that structure. There's no beneficiary anywhere, but it's still a valid trust. Public trusts, so for a long time, there have been public trusts which have purposes which are not charitable, but which are for things like provision of civic amenities and building bridges and maintaining the highway and those sort of municipal trusts. They're still with us. We've still got lots of trusts like that in the UK. I don't know about Singapore, but in the UK, we've got lots of trusts like that. It's just everybody thinks that they're some funny little sui generis thing because they're created by statute, and so they're not really trusts. They are trusts. They're called trusts. It's a trust. It's not a charity. It's a purpose trust. There are no beneficiaries. You also have trusts which are set up in order to benefit particular people, so they're beneficiary trusts, but for periods of the lifetime of the trust, there aren't any beneficiaries because they haven't been born yet, right? So strict settlements were a way in which owners of land in England for several centuries held the family estate on trust with for the purpose of preventing the current head of the family from wasting it all by gambling it away or whatever it was that he might do. And it was an important part of that structure that they'd give a life estate to the living head of the family, but then the next estate created inside the settlement would be a trust for contingent remainders, which would be essentially the first male heir. Now, by doing that, they make the property inalienable because it has to be held intact, so that when the heir is born, he comes into the estate. But if he hasn't been born yet, there isn't a live beneficiary inside that trust. Nevertheless, for centuries, the English courts were quite happy with this arrangement. It did not bother them that there was no live beneficiary. And nowadays, for example, you can create an open class of objects trust in Australia, and examples are given there at the bottom, where Nobody has an equitable beneficial interest at the time when the trust is created, but they're waiting for something to happen. And when it happens, then somebody will become one. But if you think there always must be a beneficiary or the trust is void, which is the beneficiary principle, it wouldn't be possible to create trust like that. But it is. Third point. And then I have my fourth point, and then I'm going to stop. So that's good. Third point. If you think about the remedies for breach of trustee duties, this is a sort of small point, really, but imagine you have a trustee. They owe a duty to preserve the trust assets. They can get a discharge from that duty if they pay them away in accordance with the terms, like distribute them to somebody who's a beneficiary. If they do that, then they're no longer under a duty to have the property anymore, and they can just say it's all gone now in a legitimate way. But if they breach that duty by transferring the property to someone who's not a beneficiary, or there's some contingency which must have occurred before they're authorized to distribute the property, as in Target Holdings and Redfern's, then they're under a liability to reconstitute the trust fund. But as Lord Brown Wilkinson says in Target Holdings, the liability is a liability to pay money into the trust estate to put it back to what it would have been. And Lord Millett, sitting as a non-permanent justice in the Hong Kong Court of Final Appeal, says the same thing in libertarian investments. When you're measuring the amount of the award, you want to ask what is the objective value of the property lost out of the fund. And the reason for that is that the kind of principle on which the remedies are being awarded and assessed is that the court's expectation is that when the trustees put the money back in, it's then going to be held on the original terms of the trust as specified by the settlor, and things are going to march forward because it's built into trusts, not all trusts, I know, but many trusts, that they're meant to be projected across time, and what the courts care about is that the settlor's wishes as set out in the trust terms are carried forward and that's what people mean when they say that the trust is being properly administered. That's a different idea from the idea that remedies for breach of trust are designed to compensate individual beneficiaries for loss which they suffer personally. And Bank of New Zealand is a good example of that, as breach of duty of care. But there wasn't any loss to the trust estate on the facts, but the beneficiary was upset because as a result of the trustee's negligence, he was unable to kind of pull his investment out quickly enough. And the court said, you can't have that because that's not a loss to the estate, it's a loss to you personally. So another example might be, you're the beneficiary of a trust. Let's just make it simple. You're the only beneficiary of a trust. It's $1 million. The trustee, unbeknownst to you, has just paid the $1 million out to some third party who's not a beneficiary and they shouldn't have it. And, as luck would have it, on the very same day, some guy comes to you with an investment opportunity and says, if you give me $1 million now, this is the chance of a lifetime. You can buy these shares, and I promise you they're going to go up in value, so much. You're going to be so happy. I think if actually in the real world they said that to you, you might be a bit suspicious that maybe this isn't completely what he says it is. But let's just say, miracle of miracles, he's telling you the truth, right? And you go to the trustee and you say, quickly, give me the $1 million. And they say, I'm sorry, there isn't $1 million because we paid it over to Stephen. Not a beneficiary. and you say, well, that's kind of sad. Okay, you shouldn't have done that. You should put the $1 million back, right? But that's not the only problem now because $1 million come back, but by that time your guy is gone, right? And he says, sorry, I got the money from someone else now. And look, he was telling the truth. The $1 million investment has turned into $10 million. Right? So personally, as a beneficiary, you suffered a consequential loss there. Right? Can you claim for that? No. You cannot claim for that. And the reason is because the claim for breach of duty is focused on the trust and the terms. The point of it is to have the property where it's meant to be and applied in accordance with the terms, and the fact that a beneficiary has suffered some consequential loss as a result of the breach, that's too bad. You can't claim for that because that's not how trusts work. Last point. This is about the supervisory jurisdiction and trust proceedings, which, you are all familiar with this because you're trust guys. Try explaining this to a contract lawyer, they just think you're crazy, right? Say to a contract lawyer, well, you say, well, in my world, if we're not quite sure what the trust terms mean, we just ask the court and they tell us. That's nice of them. And the contract guy's going to say to you, well, I don't get that, right? Because you have some big commercial contract, there are a million clauses, you're not quite sure what they all mean. You're sort of wondering about whether some particular action you might take would count as performance. You can't go and check with the court and ask them, would you mind telling me, what does that clause mean? The court will say, we don't do that, right? It's not our job to interpret your clause for you. Forget it. I'm only interested in that kind of question if you've got some adversarial litigation where you haven't done what you said, what the clause may or may not mean, and the other side's suing you for breach. At that point, we're going to start interpreting the clause for you because it matters to the outcome of this kind of adversarial head-to-head that you're having with the other party. But trusts aren't like that. You don't need to generate some kind of party-to-party claim for loss before the courts will help you understand what the trust is for. And that's why I say the primary function of supervisory jurisdiction is to secure the due administration of trusts in accordance with the terms. And it's only because it forms part of that wider project does it matter in cases where the trustees seem to have committed a breach, that the court will then entertain proceedings which are set up as we're suing the trustee because they've lost some money in a breach of duty and they have to pay it back in. This connects up with the point I made before about how remedies for suing trustees for breach of duty are depersonalized. But there's a whole bunch of other things which you might ask a court to do. Many trust proceedings are not brought by beneficiaries, and they're not suing the trustee for breach of duty. Many times the courts are asked to make orders other than orders requiring trustees or third parties to hand over property. You can get declarations about the meaning of the terms. You can ask for a blessing because you're a trustee, you're not quite sure whether you should do something, but it looks like the right thing to you, so you ask the court to okay it in advance. Trustees and beneficiaries might bring proceedings for variation of the terms. Beneficiaries may kind of have a dispute with other beneficiaries about which of them is entitled to the money. There's lots of stuff which is part of the court's supervisory jurisdiction, of which I would argue, these sort of trustee duty cases are only a small subset. And they're a subset which is, their point is to achieve the same thing as all these other kinds of requests which parties are making in trust proceedings, which is identify what the trust is for, what's the trust project, how are you going to achieve it, and depending on the circumstances, there are different kind of orders which will then be necessary in order to push that forward. So the bigger point here is that the way that the courts deal with requests from trust parties to do various things, including the trustees' duties, whether they've been performed or not, it's not about breach of duty and infringement of rights generating some compensatory liability. It's about taking the trust project forward. So, those are my thoughts. Summary. Trustee duties are not directed towards beneficiaries with claim rights. The undirected nature of duties owed by charitable trustees are not exceptional. All trustee duties are undirected. Charitable trusts shouldn't be sidelined when you're analysing rules of trust law. You need an explanation for all of trusts. Beneficiaries are not allocated exclusive standing to enforce trustee duties. Parties get standing to do that either because they're public officials or because they have an interest in the performance of the trust generated by their status as trust parties confirmed by the terms. The beneficiary principle rests on a false principle, a premise that you have to have beneficiaries because only they can enforce trustee duties. What I've been trying to argue today to you is that that's just not true. And the case law doesn't bear it out. It's also inconsistent with the other rules of trust law which I've described to you, including remedies for breach of trustee duty are depersonalized. What they're about is carrying forward the trust project, not about the situation of one particular beneficiary. And that links in with the function of the supervisory jurisdiction. Thank you.
We have a few minutes for questions and discussion. We've got one already, and I'm sure he'll go first.
Thanks, Professor Mitchell. Andrew Sean Allen Gladhill. Perhaps to give a view in the defense of the beneficiary principle, because obviously I've not thought through this as well as you have thought through, but it seems to me proposition number one must raise the question of what exactly is the content of the beneficiary principle, because I do not understand the beneficiary principle as actually requiring for there to be an immediately vested or a beneficiary who can immediately enforce, because it can be the future. The rule in terms of remoteness of vesting envisages beneficiaries can come later. So to me, the beneficiary principle must be a rule which cannot carry with it, if you like, an immediacy in terms of immediately vested or beneficiaries who can immediately enforce. Flowing from this proposition, it seems to me, so long as there's a contingent beneficiary, so long as a beneficiary who could be the object of, if you like, an exercise of discretion, that is enough. And such a formulation, therefore, of the beneficiary principle and the wider principle, so long as someone who's ascertainable, if the object of the powers, whom you can actually vest and what have you, and as long as you can identify that to me, if that then actually answers much of your many questions, because the alternative is really this. If you do not have a beneficiary principle as one just of standing or ensuring just due administration, it therefore means nobody can actually benefit. And that to me, I think at the end of the day, creates its own set of problems. So my view essentially is perhaps the answer lies in a reformulation of the beneficiary principle, so long as it's not too remote, so long as it's not unascertainable or fails by some of the other reasons, so long as therefore someone can actually be appointed, and so long as someone can represent that particular interest, for example, in the case of minors, that is enough. The fact of standing or other people being able to enforce cannot detract from, I think, what, in my view, the beneficiary principle serves, that at the end of the day, somebody, not necessarily immediate, who's ascertainable, is able to enforce at some point of time, if necessary, the remedies, ascertaining who can actually come about, leaving aside charities, of course. My thoughts.
Thank you for your question. So I was getting sort of two things there. So one was, I think part of what you were saying was that we need to have what I guess I would call as an enforcer principle, right? And I think it's some of what you were saying, it sounded like you wanted to say, well, the beneficiary principle is sort of an enforcer principle because the word beneficiary means is someone who has enforcement powers. So it's not necessarily somebody who's entitled to kind of a financial benefit out of the trust fund. It could be somebody else, but they're kind of a beneficiary in the sense that they're benefiting from a kind of power to enforce the terms of the trust and the duty. I'm not quite sure if I've correctly kind of understood what you're saying, but the other thing you seemed to say was that in some circumstances you might have a beneficiary a trust which is set up for beneficiaries in the sort of narrower sense of somebody who isn't just someone with standing, but is also someone who's going to get a financial benefit out of the property. And it doesn't matter if they're alive or not, because if they show up later, then they can enforce at that point. Now, I'm sorry if I've misunderstood you, but if that's what you're saying, then I agree with the second point. The first point, I think if you read Lionel Smith's article in the Current Legal Problems, he refers to the use of the word beneficiary in a kind of narrow sense and a wide sense. And it's confusing, as always, when people use one word to describe two different ideas. But in a sort of narrow sense, when people use the word beneficiary, what they mean is somebody who has a kind of entitlement to receive property, which is either already kind of coate because it's a fixed trust, or at least they have the hope of getting that in the future inside a discretionary trust. And I think that if the proposition is you have to have somebody like that in order for the trust to be valid, then that obviously I'm arguing against that proposition in my lecture. If you're using the word beneficiary in a wider sense to include people who don't necessarily have that entitlement, but who do have a power to enforce, then I agree, because I think that should be enough to validate trusts, and you can allocate standing to people who aren't beneficiaries in the narrow sense. That's my argument.
Just a quick point. I mean, thank you very much for the explanation. So it seems to me, at the end of the day, it still comes back to enforcement. It's a question of the wider, because if you like discretionary trust or subject of a power, end of the day, there's some direction, there's some correlation to what the particular rights, because then it's a rights of due administration. But ultimately, it seems to me that perhaps, rather than just looking at it as a question of standing or ensure due performance, there needs ultimately, in my view, what they call it beneficiary in a wider sense, someone which meets the criteria of what they call it ascertainability, depending whether it's power or whatever, who could fall between a particular class or whatever, because I'm just very reluctant to say that there can be a situation of a trust with no beneficiaries in the wider sense. Those are my thoughts. Thank you.
Thank you. Do we have any further questions?
Thank you again, Charles. This is wonderful on many levels, and I think my question or comment comes from the opposite direction insofar as I think I'm persuaded by your thesis. But I wanted to ask you more about the content of the enforcer principle, so to speak, right? So apart from putting the point that persons with certain kinds of interests in the performance of a trust have standing to enforce the trust, can we say more about what kinds of persons and what kinds of expertise or what positions they are in that enable them to bring such a claim, right? And you alluded to public law as well. There are institutions that sit along the private-public divide, like corporate law, which have similar questions of locus standi, and many colleagues here are familiar with corporate litigation and derivative actions as one example, right? So in that sort of sphere, we can see the law evolving from rules such as common law, fraud and the minority, to sort of broader principles when you bring a statutory derivative action, some reference to a proper person who is acting in good faith and the best interests of the company. I wonder if that is the sort of functionalist direction in which trust law should be leaning, whether we can say more about who are these proper persons who are entitled to enforce the trusts, or is it simply that they have to act in good faith and on behalf of the trust? Would that be something that is sufficient? Can we flesh out the content of that even more? Thank you.
Thank you for your question, which is a good one. I can see I didn't explain myself sufficiently clearly. If we put public officials to one side and think about the other people, I think that what I meant to convey was the idea that the reason why the people who are part of the trust for a reason other than that their beneficiaries are in, say, they have standing, and we know they have standing because the cases tell us. The people I'm thinking about are the trustees, objects of mere powers, and sorry, there's someone else. My mind's gone blank. Oh yeah, the donees of powers, which, you know, English lawyers think that you just can't create an enforcer whose only point inside a trust structure is to enforce the duties. You know, there has to be something else which they're doing inside the trust structure apart from that. But as I've tried to explain, I'm not sure that's consistent with giving employers rights under pension schemes. But what all these people have in common is that they are made part of the trust arrangement by the settlor, right? They're allocated roles inside the trust sort of project, you know, just as beneficiaries are. And it's that which gives them a sufficient interest in the performance of the trust. And the reason why particular individuals have got that is because the settlors give them that status inside the trust structure. That's part of the trust terms. Now, I mean, there are some sort of problems there because modern trust drafting practices might well lead to there being either a massive discretionary trust beneficiary class or an even more massive class of objects of a power to be added into the beneficiary class, right? So now you've got the entire world, and it seems a bit implausible that the settlor really wanted all those people to have standing. So I think I'm going to delegate this to Jessica. We need a bit more work, right, to explain why not everybody in the world gets it because because it's a massively discretionary trust. But I think that, you know, there's some comment about this by Lord Walker in Schmidt, and it's important to him in Schmidt that the applicant in that case was the settlor's son, and so he was therefore, you know, a much more plausible person for the settlor to want to have standing. But the reason he's getting it is because he's the object of a mere object of a power. I mean, one thing I would add is that when we think about allocating, what the rules are allocating standing, one way of thinking about it is trying to spot the people who've got it. But another way of thinking about it is to spot the people who haven't got it. And I didn't mention that in my presentation, but there are some cases on that. Now, generally speaking, the courts don't like, I mean, this is true in private law as well as in public law, they don't like people just showing up and interfering with other people's business, right? So there was a Canadian case called Carroll on Toronto Dominion Bank, where there was a trustee company and proceedings were brought against the trustee company by one of the trustee company's employees complaining that her employer had breached its duties as trustee of this trust. And, you know, so there's obviously something going on there that, you know, there's been some kind of internal office row, and she's a whistleblowing employee who thinks that there have been bad practices. And anyway, the court strikes it out, and they says, you know, as an employee of the trustee, you do not have standing to sue the trustee for breach of duty because you're not somebody who we would recognize as having sufficient interest in the, you know, how the trust project is carried forward to make it appropriate to let you kind of shove yourself in. So
I think that's all we have time for. Before I close, let me thank the E.W. Barker Center, under whose aegis this lecture has been given, who've done a terrific job of organizing and planning it. There will go up on the screen a feedback QR code in just a moment. I think it's there, in fact, now. And if you have a moment, the center would really be very grateful for your thoughts. the next point is that while you're thinking about feedback, I can give you some warmth to attract you, which is that we can offer you dinner. We have there's a buffet dinner outside, which I'd welcome all of you to stay and join us for. Those are all the points I have. Subject to that, I think I'd like to ask you to join me in thanking Charles Mitchell for his lecture.